Tonight, WRAL investigates the number of murder suspects who were out on bond before trial. It's an issue we've covered before. Murder suspects out in the community while waiting for trial. Now, in some cases, they're accused of committing more crimes. WRAL's Monica Casey looks into one local county's numbers and what's at stake.
An 18-year-old has been charged with the April murder of NC Central student Miles Gresham. Keenan Odom Jr. also faces charges for armed robbery and conspiracy. The indictment says he tried to steal Gresham's personal property, marijuana, and money. Odom is now in jail under a $250,000 bond.
Are you surprised by that?
Not always, and especially because in this case, he was charged much later.
Durham defense attorney Daniel Meier says bond is set by a judge using a variety of factors, including past criminal history, age, and the case status.
While it does seem low, this was also set by consent of the DA. So that tells me there's something in the case, either they're not sure it's going to actually proceed as first.
Of 80 pending first and second degree murder cases we looked at in Durham, 15 suspects are not listed in the Durham County Detention Center. That's about 19% of cases. 36 suspects were given no bond, about 45% of the cases.
You've got to look at the factors. You have to look at how long they're going to be in. And we have to remember, people who are arrested, regardless of what they're charged with, are presumed innocent.
Meier says judges have to strike a delicate balance between protecting the community and upholding a suspect's rights.
If they're released, they would have to be on electronic house arrest or electronic monitoring, so they would know where they are, have a curfew, things like that.
In Durham, Monica Casey, WRAL News.
Now, the DA's office says that the 15 murder suspects who were not in the detention center may not be out on bond. Some could be held in another jurisdiction on other charges.
This afternoon, closing arguments finished in a case that could have implications for more than 100 inmates on death row. Hassan Bakhout argues that race played a role in his sentencing for a 2007 murder in Johnston County. Before the Racial Justice Act was repealed in 2013, it gave inmates the power to challenge their death sentences if they believed racism played a role. Bakhout was sentenced to death by 10 white jurors and 2 black jurors back in 2009. His attorneys argue that prosecutors went to great lengths to keep black people off the juries.
So yeah, the Racial Justice Act was in fact a direct response to yes, McCluskey, yes to Batson, but yes also to the legislative hand in this history of racial exclusion.
Under the RJA is whether racism has existed in our state, then there is no need for a hearing in this case or any other case. But that's not the question before this court. Rather, the question is whether this death sentence in this case was sought or obtained on the basis of race. The defendant has not shown that his sentence was sought or obtained on the basis of race. He has not supported that claim with his offer of statistical evidence, other expert testimony, or evidence from his case itself, or any historical evidence.
If Bakhout's claims are proven true, he will instead serve a life sentence. The judge has not said when he will make a decision in this case. WRAL's Lena Tillett spoke with the attorney, Bakhout's lead attorney, and a top witness in the case for an edition of On the Record. You can watch that discussion now in On the Record in that section of WRAL.com.